Well, good afternoon. Good afternoon and welcome to another of our webinar Wednesdays hosted by CSU Bakersfield Small Business Development Center. This is episode number 258. Good afternoon. I'm Kelly Bearden. I'm the director of the CSUB SBDC and your host for today. We'll be joined in a little bit by Celeste Young-Ramos, and she will discuss a lot of the restaurant, but more importantly, the HR changes that are coming to all of us in 2023. So what's up today? I have a little preview of what's going on today on January 11th, 2023. Well, it's another year. We're getting to that point to where I can no longer, in good consciousness and faith, wish anybody a happy new year. We're 11 days into the new year, but it is another year, and we have new laws and regulations courtesy of the state of California and others. And those are for your business and for most businesses in 2023. So we're going to go over those today. And we'll have our program update, which will show you the programs that are kind of still open and still available to small businesses and individuals. And we'll continue to look for value for you and try to see value in these particular programs that will help you sustain and grow your business. We'll talk about some of the notable news that you need to know. Notable is an interesting word, not able if you were to hyphenate it halfway through. But I don't hyphenate. So it's notable news you need to know, and we'll go through a little of that today. We'll have our economic corner. I'll talk a little bit about news from the Federal Reserve and the Federal Reserve Chairman Jerome Powell and some of his comments and things as the minutes of the December meeting were made public recently. We'll talk about our capital quarter, and what we'll do is we'll follow on the ERC, the employer retention credit, and some issues and some observations that I have, and kind of some interesting things that came up in the last week on that. As I mentioned, our HR and restaurant guru here at the CSU Bakersfield SBDC, Celeste Young-Ramos, will join us today. We want you to stay notified in 2023, so keep attending Webinar Wednesdays. At the end, we will take your questions. So if you have any questions regarding any of the content of today's webinar, please go to the Q&A box. Maureen Busher-Dang is our producer, as usual, and she will be populating the chat box with some information as it comes up. So feel free to grab those. And as always, or as usual anyway, we'll have a poll, and let's get into that poll right now. We have two questions. One of these poll questions has been asked fairly recently, but I thought it was important to ask it again based on our content today. And it is what you anticipate as far as hiring plans for 2023. Do you hope to add staff? Do you hope to retain your current staff? Would you like to reduce your staffing levels, or you don't have any plans at all? You don't have any plans to reduce or add. So add staff, retain your current level. You'd like to maybe reduce and cut back on some of your staffing levels, or you don't have any plans to do any of that. So jump right on in. Wow, we're already up to 69% of you participating on the staffing questions. And there's some interesting things that have been happening on staffing. And we'll talk a little bit briefly about that, some of the surveys that are showing up in other areas. But our first question is your anticipated hiring plans for 23. You're either going to add staff, you're going to retain your current level, or you don't have any plans at all, or you would like to reduce employees. So with 80% of you in, that's a great poll number. We're going to end the poll right now. Last call. And there we go. And share the results with you. And sharing the results, we see that 45% of you are looking to add staff. Now that's fantastic, because this poll is pretty much along the same lines of the last time we did this poll, which showed 50% of you wanting to add staff. And second is you hope to retain your current levels, which was at 43%. And then lastly, you don't have any plans at all, 14%. And also, for the second time that we've done this poll, nobody wants to reduce their current levels. So on a lot of the national polls that we're seeing about that number, about adding staff for small businesses is closer to 25%. With, reducing and maintaining the current levels about the same, 41%, but also adding or don't have any plans is somewhat larger. So locally, I think we're seeing individuals and businesses want to do more on that particular area, and that is always a good thing. So we will stop sharing that particular poll result and move on to our second poll, which is a little bit more whimsical. So this poll question, a little bit more whimsical than the other one. And what we will do is open poll question number 2. And it has to do with some comments from the governor yesterday on actually the California having a somewhat budget shortage in 2023 that's anticipated. And in some of the quotes that I read, there was some comments by the California Department of Finance that keeps all the financial projections and records in the state of California. So the California Department of Finance, according to the California Department of Finance, the richest Californians, identified as the top 1%, pay how much of the total income tax collected? Is it 25%? Is it 49%? Or is it 75%? So the California Department of Finance says that the richest, ultra wealthy Californians, the top 1% out there in wealth, pay how much of our total personal income tax collected? Is it 25%, 49%, or 75%? Might get you on this one, might not, but I figured it'd be worth a try. Kind of interesting and kind of on how it's going with, a lot of the richest Californians leaving. Let's see, we had Elon Musk leave and things like that. So according to the top 1%, we have about 87%. Boy, you're responding today. I'm going to end this poll right now with 87% of you in. And thank you for voting. And I will share the results according to 1%, the top 1%. And the results, your results say 25%, 1/4 of the entire personal income tax collected is paid by the top 1%. That answer is incorrect. So 46% of you, we got there. The correct answer is the second one, 49%, or nearly half. The football playoffs happening starting this week. I couldn't resist a good 49% poll question, and that was it. 49% of the total income taxes paid by the top 1%. 29% of you got it right, and then 26% at 75%, which at probably one time it may have been. Who knows? So thank you for playing along with the whimsical question of the day, and let's move along. So some of the notable news that I would like you to know is based on the hiring question that we just had. In those surveys, it's suggesting that it's getting easier for small businesses to find and hire employees. That's a great thing. Also, employees that are seeking remote work are really kind of getting inundated with scams where they're not really applying for jobs and providing a lot of personal information. The big tech layoffs are continuing in employment news, but really kind of the key in all this comes back to the Federal Reserve and what the Federal Reserve is doing to fight inflation. And the Fed wants more job and labor cuts in order to fight inflation and to increase interest rates, and to do so basically hoping for a soft landing where they can do this without creating a recession, but they do want to slow the labor market and the inflation that is created from the labor market and that job growth out there. So that is what's notable today. Some of the programs of value in 2023 that we want to keep sharing with you. We've talked a little bit about the RRF, the Restaurant Revitalization Fund, that there is a tax credit that is hopefully circulating through Congress. It is happening right now. It is proposed. It is not law. Remember, it is not law. And the way it would work is that if you applied for the RRF grant and were one of the 66% of the restaurants or food or beverage type businesses that did not receive funding in that program, that you would be able to apply for a tax credit that is going to be created maybe. So that is what is out there, and we'll continue to follow that in 2023 to see if that is helpful. On the job training, I made a point of talking about this the last few weeks at least, and maybe bordering on the line of several weeks, but the on-the-job training programs that are available through your America's Job Center programs, they are reimbursing, up to 3 months of training for new employees. And again, too many of small businesses do not participate in this particular program when you have a training intensive employee that you're bringing on board, and this is a great opportunity. We've talked about the employee retention credit, probably at least a year and a half on Webinar Wednesday. The employee retention credit remains active for some that were affected by COVID. Technically, the program ended with the third quarter of 2021, but there is a lot of still efforts going on for people to go back and recapture that. We're going to talk a little bit about some of the consequences. 2 weeks ago, we had Jay Thompson on, and he gave us his observation of what he saw in the field in working with SBDC clients that were going through employee retention credit and some of the issues that ranged from them needing to go back and to potentially actually amend a tax return and we'll talk about that, and a few of the other consequences that are going on. And also there are more debt funding programs online that continue to come. So keep your eye out if you're looking to obtain funding to grow your business in the future. Our capital quarter just reminds that the EIDL deferment for those that have the economic injury disaster loan is coming due. The California micro grant program here in Kern County is still open until May of 2023. There are several issues that you need to be reminded of. And right now, let's focus a little bit on the ERC and some of the issues and risks that we're seeing that pop up. Again, as I think we've mentioned for a long time, there's a lot of individuals. Jay mentioned 2 weeks ago, there are a lot of what he called ERC mills, that these establishments that pop up in order to assist those that are paying payroll taxes and have employees with filing an ERC application for that tax credit. And remember, it is a tax credit, but it can be refundable. So, you can get the money right away rather than waiting to offset it against future gains. I think since the onset, advised you to check with your tax professional. Now's a good time. It's tax season coming up. And if it's something that you could go for, what they do is they go back and they amend a 941, which is your payroll tax, your quarterly payroll tax that goes to the federal government, that lists your sum of your employees' wages and the taxes that were collected. And so, you can go back and amend the one back to, let's just say, September 30th, the third quarter. But that could also affect your personal and business tax. One provision of receiving the ERC is that you have to reduce your wages for that period by the amount of the employee retention credit you receive. So if you received $100,000 for the taxable year in 2021, if you filed a tax return with the full amount of wages on there for tax purposes, you need to show it $100,000 less for the credit. Now, in the long run, sure, the credit is much more valuable to have, but there's some other issues that are coming up again. You have to be eligible. You have to remember that there could be an amended filing coming on and some other things. So when I'm perusing my email this week, I get this email, and it is from Bottom Line Savings Concepts, and a legitimate firm from what I checked online. Had done about a couple of $2.5 billion in ERC. So I get this email saying I could get a refund for California State University Bakersfield. Well, if I get a refund for CSUB, I'm probably going to end up in jail. So that's something I don't want. And CSUB doesn't pay income tax anyway. So why would they be able to apply for a retention tax credit? So normally if something comes up like that, I would refer it to the VP of Finance, Ms. Queen King over at the university. But this one didn't even seem worthwhile to do because I knew in advance that there was no way to qualify. So what this is it's a very aggressive targeting email campaign in order to say, hey, you might be able to qualify for up to $26,000. Again, from what I could tell online, this is a very legitimate firm that is doing this. They're just doing it in a way that's a little bit aggressive. So that was the first day. And then the follow-up to yesterday was bumping the previous email. I called it doubling down on an unsolicited email, but they're doing their marketing and their due diligence, and they're doing it that way. So highlighted in bold, you don't pay them a dime. But many of these places they're charging you a percentage of what they get you. And if online, I noticed they said their average amount that they got for a client was $200,000. And if they're taking a percentage, say 20%, $40,000 is a lot of money to be paying for that. Maybe it's 10% or $20,000, which is still incredibly a lot to pay, considering all you're doing is doing an amended return. And in one of these emails, they said, look, we have not had a single audit from the IRS. The IRS, to my knowledge, hasn't started to audit and review these. They're still getting these tax credits out. But there's a little thing in some of the stimulus packages that is resulting in a lot more IRS agents come along. And I think, as Jay Thompson from the SBDC mentioned a couple of weeks ago, he expects to see them get pretty aggressive in reviewing and looking at if these are audited. So still, one thing you really need to check into that and really kind of look into that. And really, it's a good time to talk to your tax advisor if you're looking to maybe go that particular route. Let's move on to the economic corner, where the economy intersects our small businesses. And we talked about Jerome Powell and some of the things that he had mentioned going on. He says we need to drive interest rates higher. Also won't let climate mandate policy. So basically what it's saying is we need to drive rates higher, and politics are not going to drive those rates and mandates. So the climate mandate and politics will not affect economic policy in his need to raise interest rates, because inflation is still the key. So just a few tools that we're showing off today from our SBDC toolbox. We have our Webinar Wednesday and Live Plan, our interactive live planning tool that you can contact us if you're looking to do a little business planning. But let's go to our special guest today. And our special guest today is Celeste Young-Ramos, and she's the founder of Restaurant Success Center, a restaurant and human resource consulting firm providing restaurant owners, managers, and basically anybody who has employees with skills in order to grow, maximize profits, and to satisfy customers and employees. She advises our clients on restaurant and human resource issues. Vast experience includes several chain franchise operations. I know one of them had about 75 locations. And also she's worked with hundreds of independent restaurant and food service operators. Celeste has over 20 years of experience as human resource manager and franchise director for Denny's in Southern California, and has worked with several independent restaurants and gaining them their profitability and helping them during a very trying time for restaurants. Celeste, welcome. It's great to have you back on Webinar Wednesday. Looking forward to hear these updates, so please jump in and take it away.
All right, Kelly. Well, it's always nice to be here for sure. And I'm glad to see that the weather has improved a little bit for us all. So let me get my slides going here. So welcome, everyone. I'm Celeste Young-Ramos from the Restaurant Success Center, and I'm going to take you through the updates for the 2023. So these are going to be related to pretty much every business out there. So they should apply to most of you. Most of them are for small businesses. And as Kelly mentioned, I am a human resource advisor and restaurant advisor. So let me go to the next slide. So I'm going to go through the 2023 wage laws that have changed. Well, there's been a few leave of absence changes that are now available to our employees. I'll talk about a notice about COVID-19 exposure And then we'll finish off with some other new laws and things that you should be following up on right now. And then we'll have some time open for questions. So the first one is the state minimum wage went up. Now, we all knew it was going up in January, but I was under the impression earlier in the year that we would be at $15, but we went up to $15.50, which was a shocker for many. And that happened as of January 1st. And why it went up to $15.50 is because it was a part of the law said if we reached inflation of 7%, it was going to kick in the cost of living increase. So that was triggered and it brought it up to $15.50. And that's regardless of what size, whether you're over 25 or under 25. So all companies that fall in the state jurisdiction should be paying that. Now, there are 19 other cities throughout California that pay a higher wage. I know I'm from the LA market. We're paying $16.04. And some of the cities, these 19 cities, have the wage increases in July. Some of them are in January. So if you're not sure, you should definitely check out where you're falling in there. All right. So with any minimum wage increase, that also is going to increase the amount you have to pay your exempt salaries. These are the people that you're stating are your managers, and you are not paying them overtime or having to worry about their breaks. So these are just for the ones that are exempt from the break and overtime rules. So whenever a minimum wage goes up, that causes an increase to them. The law is you have to pay them 2 times the state minimum wage times 40 hours a week. So when I did the calculation, that came out to $64,480 per year. So if you have someone on a salary, they have to be making at least that much so that you can take advantage of the overtime and break exemption. And as we go through, if you have any questions at all, please put them in the chat or use the raise hand function, and I'll be glad to answer your questions when we get into a break period. So for the food restaurant industry, last year we saw the Fast Food Recovery Act, AB 257, be introduced. And why this occurred was that there has been a lot of incidences where there's been wage theft, particularly in the food industry. There was a study conducted earlier this year that 85% of California fast food workers claim to be victims of wage theft. And the most common ways that they felt they were having their wages affected was they were being denied sick leave, 59%. So that is the majority of, over half the employees weren't getting sick leave pay. And as I go through and do audits at different businesses, because sometimes businesses will hire me to come in and see where they're at with their HR practices, trying to avoid PAGA lawsuits. We'll find that, if I ask about sick leave, a lot of people don't know it. And that right away, that signals to me that you aren't giving out the Wage Theft Act form in the your new hire package, because that is it's on the one where you put down how much they're getting paid and you distribute that to the employees. Also, there's issues of 27% violations in overtime and minimum wage, and 53% reported they weren't getting their rest periods, or they were being interrupted without proper compensation. And that is one of those things that we've seen business after business with private attorney general lawsuits, where employees as a group are able to form almost like a class action, and there's huge fines if you're not doing breaks and meal periods correctly. So I would definitely make sure that you're ensuring everyone gets those breaks, or have some kind of automated system that if they don't get their break or their break is short, that they automatically get paid the 1 hour's wage for the 30-minute break they missed. Because the fines, if you get into one of the lawsuits like this, the penalties are up to like $200 or $300 per incident per week that it happens per individual. So when we're hearing lawsuits of $100,000, couple $100,000 or more, that can easily rack up. Now, so what's happened, it kind of incited the creation of this Fast Food Recovery Act. And last year on Labor Day, Governor Newsom signed it. And what it said was that restaurants that are either fast food or have counter service, like a fast casual restaurant where you come up to the counter and order, they could be have to be led by this 10-member council. Now, this is affecting large chains, so it's affecting 100-unit businesses. So if you're small, it's not going to affect you today. But what ends up happening at these large chains, it ends up funneling down to the rest of us, right? So this council was supposed to go in effect this year and be in effect up until 2029. However, there was a new development and 1 million people in the state signed a petition to block it and force it to go into a ballot vote in 2024. And it's being looked over by the court system right now as well. So we may see something about this coming out next year. One of the biggest key things that was worrying employers was that it could cause them to raise the minimum wage to $22 an hour for these employees as the minimum wage. So that's, $7 difference from where we are now. So we're going to have to keep an eye out and see what happens with that one. Now, starting on the 1st of this year, if you have 15 employees or more, you're now required to provide wage and salary ranges to the employees. So there was already previous legislation that said, on your applications, you cannot have on there what was your previous salary or wage. Now, I see that out there in the field all the time, so check your applications. There's 2 things that shouldn't be on there, the wages and salary, and also if they've been arrested or convicted of a crime. All right, so that's illegal to have those on the applications. But now they have included that these salary ranges have to be disclosed to the current employees. So if the current employees want to know what the salary range for their position is, that you have to openly tell them. And you also have to include it in all your job postings. That includes ones that you post in the restaurant, and if you're posting it on any online application thing like in Monster or Indeed or whatever. Okay. And then now you're also required to keep records of the job titles and wage histories for each employee during their employment plus 3 years after their employment ends. So you'll have to have that somewhere. As you give people raises and things, you'll need to be able to keep a track of that either through your payroll system where you can print out the report, or you need to keep a form in the employee file that will list this information of their job title and wages, and then keep it for 3 years. So, and that's to make sure that people are following the Fair Wage Act of giving equal pay for equal work to all employees. The fine for non-compliance is $10,000. So they're very serious about making sure that people are aware of what their wages are available. Someone asked, do you have to post all the pay scale disclosure or only if an employee asks? You have to post it. So for any applicant that you interview, you have to tell them. If you're making a written job posting, it has to be included in the job posting. You can't just say competitive pay or commensurate to experience. It has to actually have the range there, okay? And in some positions, like in server positions where we just pay minimum wage because they really get a lot of tips, you can just put the 16, whatever the way, $15.50 for the state, or if you're in an area that's a little bit higher, because of local jurisdiction, you'll just put down that amount. You won't have to put a range. You can just say, this is it. That's the number. Good question. If you have over 100 employees now, they're requiring you once a year to submit the mean and median wages for different positions in your company, and also the demographics like sex and race on there. I didn't include a lot of information here because the majority of the people here are small business entrepreneurs, so it probably won't apply, but if it does, you can always look up SB 1162 if you are one of those fortunate large employers. Also this year, IRS increased the mileage reimbursement. It's now up to 65.5 cents per mile, driven for business use. If you have a nonprofit organization, it's set at 14 cents per mile. So those are some numbers you may need to change if you've been reimbursing your employees by that level, by the IRS reimbursement level. Also, I wanted to bring up phone reimbursements. I was on a conference call earlier today with a prominent lawyer that represents tons of clients for PAGA lawsuits. And one thing he was going through and talking about some of the things that seem to be the big sticklers with in these lawsuits is phone reimbursements. I can't say the word today. Reimbursements. So what we're seeing out now is we're getting a lot of apps on our phones that help us communicate with our employees. And those are all well and good, and they're tended to help us to have better communication. But if that's the only way we're communicating with them is through their cell phone, or that's the only opportunity they have to clock in through their cell phone, then you may be required to have to pay them for cell phone usage. Now, he said the strategy to get around that is that you have in your handbook that states that, you know, you may be using these phone applications for communication, but they're only being used as a convenience to the staff. And you'll still continue to post like if you're using the My Schedule app, you know, you can still send it out to the employees if they're opting in to use it. But otherwise you have to post it somewhere in the restaurant so that the employees have access to it if they don't want to have a cell phone to participate with that. Also, like if you might have them, you know, putting requests for leaves on the app on the phone, if you're having them do that and there's no other way that they can do it manually by paper, then you may have to pay them a part of your cell phone bill. So just be aware of that as it may affect you. Okay, is this disclosure posting required based on location employee count or based on company count? It's based on the location count. Good question. All right. Now, the Family Leave Act. This is one that they've made a change in it. Before, you know, it covered yourself and also taking care of like immediate family members. This is where you could get a 12-week unpaid job protected leave of absence. This usually applies to companies that have 50 or more. They have designated it now that they have what they call a designated person. So like many times people are living in a household with someone, you know, that has almost like a family relationship, but, you know, they're not a blood relative. They can now have one designated person that they can request the leave to be out. You as a company can designate that they can only choose one person per year. So they can't just like go from this person to that person to the next person to get the leave. All right. Now let's go to the next one. And here's a new one that just came out this year, January 1st, 2023. If you're an employer of 5 or more employees, you need to provide 5 days of leave to employees who have a qualifying family member pass away. And this is unpaid. You don't have to pay them. It's not like sick leave, but you do have to hold their job and allow them to be off for up to 5 days. So that's for a spouse, a child, a parent, a sibling, a grandparent, grandchild, domestic partner, or parent-in-law. So really very close line, no aunts or uncles there. The employee has to have been employed with you for at least 30 days at the time they want to take the leave. And they have to use this leave within 90 days. So perhaps they take 2 days off to go to the funeral, but then later they need to take more time off to help assist them with, solving the state or whatever. Those days just need to be taken before 90 days. And it says no limit of leave. So if there's multiple people in the family that die during the year, according to law, they can have those times off. Now, I know some of you are probably saying, well, I've had one employee say their dad died 5 times, you can ask for proof, that there has been a death if you are suspicious of the time off. All right. Now let's go to the next one. Now, there's been a few changes in COVID-19 reporting rules. Before the law used to say that if you had a positive case, you had to, in writing, notify every single person that worked at that location to notify them that there has been an exposure. That has now been changed, and they're just saying that you have to post a notice. One notice, not to every individual, but it needs to be posted and communicated in a place that everyone looks, like maybe near the schedule board, or if you have a payroll portal, post it on the payroll portal. It has to be that people are known about it, okay? Also, before, if you had an incident or if you had several people get sick, you were required to report it to the health department within 48 hours. And that has now been waived. So you're not required to let the health department know about it. All right. There also was a new law called emergency conditions. And this one prohibits retaliation against an employee for refusing to report to work or leave a place of employment during a natural disaster or criminal event. So during these times, like sometimes during natural disasters, we might want to keep our employees there to help with onslaught of customers, for instance, that often come into restaurants during natural disasters. But they're saying that if an employee doesn't feel safe there during that time, that you have to allow them to leave. Or if there's a criminal event, maybe there's a shooting in the restaurant or something like that, they can be allowed to leave, make phone calls to tell family members about it. All of that has to be able to occur. Luckily, we don't have that many types of events on a regular basis, right? All right, now here's a new one on protections of off-site, off-duty marijuana use. So this new bill, it was just passed, but it doesn't go in effect until next January in 2024. And what this does is prohibits employers from discriminating against applicants or employees because they have used cannabis off the job and away from the workplace, were found to have non-psychoactive cannabis metabolites in their hair, blood, or urine when they've done drug testing. Okay, so you can still do drug testing in your workplace. That's fine. You just need to make sure employees are noticed and that it's in your handbook. You still can not expect to see marijuana in the workplace. That could be grounds for termination for having marijuana in the workplace. And you can still have a drug-free workplace if that's the environment that you're wanting to have, where they have to take a drug test and nobody can have any drugs. So that is a possibility as well. These laws that I'm going through today, they do apply to everyone, not just in restaurants. Good question. Yep, that's the answer for that one. Okay, Now, as you know, we've been doing CalSavers. The state of California recognizes that there's probably going to be a shortfall for retirement funds, maybe through Social Security. So they have instituted an employee retirement program. And so far, if you have an employer of 5 or more, you should have already signed up your company either to CalSavers, which is the government-run program, or through a retirement program through an insurance carrier. You're not required to do a match with this, but the employees have to have a vehicle to be saving toward their retirement. And they made some changes with the CalSavers program in particular. Before, they were allowing sole proprietors or self-employed individuals or other business entities that did not employ any individuals to participate. And they have made a change in that, and you can know that those individuals can no longer participate. Now, the bill was recently expanded as well. So in 2025, at the end of 2025, no matter what size business you are, you will be required to provide this retirement program of some type. Okay, so I see a question came into the chat. Teresa asked, if an employee has an accident and is found to have evidence of cannabis in his system, but he says he did it several days prior to coming to work, can I fire this person? Good question. That's a question I'm not 100% confident in asking. I think it's going to depend. If you have, like, some companies have a policy, like if you have an accident, you have to be drug tested, or if you get a promotion, you're drug tested. And if it shows up at that time and it doesn't show that they have a prescription for any type of cannabis medication, then that could be grounds for termination. Because if it's showing up in their bloodstream, there must be some level of it there. But I would always discuss that with an HR individual for each individual case. But I know that was previously that was an effective, when I worked at Denny's, that was a policy. If you had an accident, you had to get drug tested. Or if you had a workers' comp, like driving the car accident, you had to get tested as well. And that did seem to also limit the amount of workers' compensation claims, because sometimes employees did not want to get drug tested. So, all right. We did mention earlier the employee retention credits. You only have up to 3 years to amend your 941s. So if you, the first quarter that it was eligible for was second quarter 2020. So you would have to make sure you make that amendment here quickly for this next quarter if you're going to take advantage of that program. And this kind of tickled my memory as well, because Kelly was talking about the restaurant revitalization funds that they're trying to get pushed through. They did notice, the auditor of the program did notice last year that they didn't distribute $180 million for that program. And I know the California Restaurant Association and many others are lobbying to get the rest of those funds distributed. So if you had put in an application before, there may be some, hope out there in the distant future that that money will also get distributed. So with these new laws that I mentioned, there were 18 changes in laws, minor changes over this past year. And also the minimum wage has changed. So if you have like a California poster with minimum wage on it, it's going to be incorrect. So you'll need to probably update your labor posters at this time. It would be a really good idea. Another thing would be a good idea is to always update your employee handbooks at that time. And also in relationship to the PAGA lawsuits, where the employees could band together as a simple class to bring a lawsuit. There was a ruling this last year that allows you to use an arbitration agreement to arbitrate with just the employee directly and not bring the rest of the employees into it. So I've been to several workshops on the PAGA lawsuit because that is what a lot of my clients are trying to prevent. And they said that, you need to have an attorney do it. Don't just get an arbitrary one that you're finding, like you Google images for arbitration agreements. It's that there's certain wording that has to be in there for it to apply. So you might talk to your labor attorney to get a new arbitration agreement with you. Just to be clear, we cannot hire someone because they have marijuana in their system. Well, I don't know if your question is clear here, Diana. I mean, if they have marijuana in their system and you're a drug-free company, that's your standard, that none of our employees use drugs, then you're not required to hire them. But if you do a drug test and they put down that they are using medical marijuana, you may be required to hire them because it's a medication. They just can't be using the medical marijuana. Like if they have to take it 5 times a day and one of those times happens to be during your time at work, then you can say we don't allow drugs here on work, and you can allow them. They cannot take it during work. Okay, good question. All right. And those were all of the updates that we had during this time period for this year. There was quite a few more last year than this year. If there's any questions, I'd be available to take some open questions here. And here is my email and phone number if you need to get in touch with me to do a consult here at the center, or if you would like to have me come in and do an extensive review of your HR policies. I had a client recently that's very successful and has been in business for like 21 years. And I found they were a hot mess in accordance to what California wants for labor laws and things like that. And we're really putting themselves at a lot of risk. So if you haven't done that for a while, I would encourage you to find someone to touch base with and have your things looked over. Thank you very much.
Celeste, fantastic as always, first of all. Now, did you see the question in the Q&A, or did I just miss that one being answered?
I already answered that one earlier.
Oh, gosh. Well, then what is the answer? Because I missed it.
It's based on your location.
Okay.
Yeah.
Perfect. So what are you seeing as far as we talked about the HR side? We got a few minutes left, and so I'll play Stump Celeste if I can. So on the other side, you do a great deal of restaurant consulting. What are you seeing? What are your general observations with the current state of the restaurant industry and things that you're seeing in that particular segment?
Well, in that particular segment, in regards to HR issues, is a lot of violations on breaks. People are like they're sending people on breaks, but they're asking them to not leave the premises, or they're asking them to be available by cell phone. And that violates them being able to leave completely. So in your your break policy, you should have in there that they can be allowed to leave the building and be totally relieved of duties. Also, the law says they get a 10-minute break for every 4 hours they work, or fraction thereof. Fraction thereof means if they work 3.5 hours or more, they should get a 10-minute break somewhere in the middle of their shift. The lawyer today was mentioning that you really need to make sure your break policy has that "or fraction thereof" phrase in there, that it can save you a lot of trouble disputing it. Those are probably the biggest things that I've seen. A lot of people have kind of forgotten that if you're an employer of 5 or more, you have to do harassment prevention training. And so we're seeing lots of people out of compliance there. So employees, if you have 5 or more employees, you have to provide 1 hour of employee training on harassment prevention and bullying, and 2 hours training to supervisors. So that's for any industry out there in the field. But, restaurants are the biggest offenders of sexual harassment complaints. So that's particularly important to us. And of course, inflation on prices right now, egg prices, if you're a IHOP or a Denny's or some kind of egg business, I'd be crying right now because I believe egg prices have doubled. And that's what we see in the grocery store, 7 something for a dozen eggs. So, people need to take strategies right now with eggs or any other ingredients that you're serving to raise the prices. And right now, with minimum wage being higher, you need to raise the price to cover that. So, don't delay and take your price raise.
Well, you seem to have frozen, at least on my end, Celeste. That is kind of what I'm seeing too. I'm hearing from a lot of restaurants out there right now that with a lot of the costs that have increased, that what they're seeing is it's difficult for them to raise prices. And this is also very, very common, I think, with some of the non-franchise and non-chain restaurants. So you have they're much more susceptible, from what I am seeing, to price increases like eggs and some of the other things. So that is what I'm seeing. And had a couple more questions. We'll see if we get Celeste back here. And Celeste is back. Celeste, I think there's a couple more things in the chat.
Okay.
And maybe one Q&A question.
Okay.
I gave my quick observations of what I've been seeing and talking to restaurants, and that is that it is really kind of difficult out there because you've raised your prices so much already, and there comes to become a saturation point on where they just can't make any money anymore and raise their prices. So
yeah, I kind of tell people right now, if it doesn't make you a little embarrassed to say the price, then it's not high enough, unfortunately. But it will reach a point where consumers will say, I can't afford this, and they may decide to shop at home and eat at home, but still the prices even in the market have been accelerated. We're up like 12% in inflation on food costs. So some people will still end up paying the price if that's what they desire. And Marisol asked, can I pay more than minimum wage? My question is, how often can an employee ask for a wage increase? Well, they can do it every day if they want to. They might not have a good relationship with you, but there's no rule on how often you have to give wage increases either. Typically, most companies will do it once a year. After they do the employee's performance review, it's a good time for that. Okay, any other questions?
there's a question, can you include benefits in your pay range?
Oh, definitely. I mean, if you're saying listing them as these are the things that we offer, definitely I would list those. One thing I see, like, a lot of companies are super small. They go, well, I don't have any benefits. Well, I always say, well, what are things that could be attractors? Number one, you're mandatory required to give sick leave. So you can list that as a benefit. You can list that you're closed on like Christmas and New Year's. For many restaurant workers, they got to work on those days. That you have a family-friendly environment, that you do educational reimbursement, or all kinds of different things. So all of those things can definitely be listed and will attract employees. And I would check out competitors like Taco Bell is like one of the best for hiring example, or like In-N-Out Burger. I would check their website for hiring things, see what kind of things they're offering as benefits on their sites.
Great points indeed. One last question in the chat.
Sure.
I think that I have found here. Are part-time employees who work less than 30 hours per week counted as employees for 5 or more?
Yes. Mm-hmm.
So that would be for the California Job Savers program.
Yeah, for any job, it's counted as an employee.
30 hours more. Great. 30 hours or less, I should say. Well, fantastic. Well, Celeste, thank you so much. Great to have you here. Fantastic job as always. And that'll do it for this week. So we'll be back next week for webinar Wednesday number 259. So join us if you have any questions where Celeste could help you from the SBDC's perspective. Some of her stuff is we really don't work with, but a lot of her consulting efforts we do, and we have her work with many of our restaurant clients. Some of those areas, like creating a job description, kind of beyond the scope of what we do. So reach out to us, reach out to Celeste, and we'll be back for number 259 next week. So everybody have a great week. So long, everybody.
Thank you. Bye-bye.